Good afternoon, ladies and gentlemen. My name is Koji Watanabe from Tokyo IP Consulting. Thank you for participating in the Tokyo seminar today. So, first of all, I'd like to briefly introduce myself. I registered as a patent attorney in 2006, and for about 20 years, I have been supporting research companies, small and medium-sized enterprises, and university researchers in Japan and overseas. During that time, I have been involved in many dispute cases, and some of the cases I have been involved in have been widely reported in Japan. In addition, I have recently been writing various papers on intellectual property and economics. I'd like to put more effort into these areas in the future. Next, today's speaker will introduce himself. Thank you very much, Dr. Hobbs.
Hi, everyone. I'm John Hobbs. I'm in the Atlanta area. I'm here in Japan for a few weeks visiting clients and colleagues that I'm working with. I've been a patent practitioner since 2010, so about 14 years now, and worked with a lot of semiconductor manufacturers, automotive industry, scientific instrument industry, and software companies, and helping them get patents in the US. I'm here to help some of the Japanese companies that are wanting to apply for patents and do some kind of patent search in the US. I'm here to help them out, and I'm glad you could all attend the seminar today, and looking forward to talking with you afterwards. So thanks, Coach.
Thank you. But I'd like to give a short presentation as an introduction. Video will be turned off to reduce the load to communication lines. As I explained earlier, in the seminar, Dr. Jonathan Hobbs will give a lecture on patent search using artificial intelligence. As you know, the use of AI is currently progressing in various industries, and it seems that the use of AI is also progressing in intellectual property field. The introduction of IT technologies, not just AI, will improve the efficiency of the process of acquiring intellectual property rights and responding to lawsuits. It will lead to increased profits of business entities related to intellectual property. As I have pointed out in my past papers, the automation of these various processes will increase the profit of business related to intellectual property, and this will lead to the freeization of intellectual property rights and the promotion of innovation. Based on this idea, attempts at patent search using artificial intelligence, as described today's lecture by Dr. Jonathan Hobbs, are extremely meaningful and should be recommended to various business entities. With that in our mind, although some people who specialized in patent searches are attending to this seminar, I believe some people may not be familiar with patent searches, so I'd like to provide an introduction on what has been commonly pointed out in patent searches. At the same time, I would be happy if I could introduce you to Tokyo IP Consulting, the IP law firm I work for. First, on the first slide, when conducting a patent search, it is necessary to clarify what the purpose of the patent search is. This is because depending on the purpose of the search, region and scale of the search should be different. Generally, the purpose of patent search can be broadly divided into three categories. The first one is prior art search before filing. This is mostly done to understand the position of a company's technologies in the industry in order to formulate strategies for technological development and patent application strategies. Next, there are cases in which searches are conducted to gather evidence when submitting the third-party observation or invalidation trials. This is commonly referred to as invalidation search. In the case of an invalidation search, it is necessary to conduct the search to the extent that enable to invalidate the target patent. Final one is FTO search. This is to find out whether there are any other company's patent that could be barrier to bringing a specific product to market. If you encounter infringement of patent rights after the business has started, there is a risk of being sued by a competing company in the worst scenario. So this is done to reduce such risks. Go to the next slide. The number of documents that should be searched varies greatly depending on the purposes of the patent search. For example, in the case of prior art search, I think it would be sufficient to review approximately 100 to 200 documents in the language or the patent office where the application is filed. This is because in Japan, the cost is often less than 500,000 yen, even examination fees are considered. So it is disadvantageous to spend a large amount of money on a prior art search. On the other hand, regarding invalidation search, depending on the case, for example, reviewing around 500 to 1,000 documents in 8 languages. Here, in invalidation search, we do search not only in English literature, but also in Japanese or Chinese. Depending on the technical field, some invalidation materials may only be published in Chinese and Japanese, and may not be available in English. For this reason, if invalidation materials are not found through invalidation search in English only, we may conduct search in the other languages, such as Japanese and Chinese. Finally, regarding FTO search, we often review over 10,000 documents, depending on the size of the business. In particular, when a product is launched in the US market, we have to review the publication very carefully. This is due to a punitive compensation system in the United States Code. As you well know, the amount of compensation can be extremely expensive. I have heard that in some cases, companies involved in patent infringement lawsuits are forced into bankruptcy. Considering these backgrounds, especially when actually starting a business in the United States, it is recommended to conduct a large-scale FTO search, even if it may be cost-consuming. Go to the next slide. Recently, various business entities are conducting patent searches. However, it seems best to conduct a search with the involvement of patent attorneys or patent agents. But what is the reason for this? First of all, when conducting patent searches, patent attorneys and patent agents are able to review various documents based on the Patent Office actual guideline for determining patentability. In particular, in the case of Japan, even if all the features in the claims are simply disclosed in the cited documents, inventive step may not be denied, depending on how such features are disclosed or connected. Patent attorneys are familiar with the situation in which the inventive step can be denied, as well as the situation in which the inventive step cannot be denied in various case studies. Therefore, by involving a patent attorneys or patent agents in the patent search, it is possible to conduct a search in line with the examination guideline for the Patent Office. Next slide. Furthermore, in patent searches, it is important not only to examine the technical matters described in documents, but also to find out by what kind of applicant the document has published or when it was filed. By considering these situations, it is possible to understand the overall position of the technology disclosed in the publications. Patent attorneys often make such judgment in their experience in litigation. So this can be an advantage of asking to conduct patent searches to patent attorneys and patent agents. Then the next slide. Here, I'd like to talk a little about the difficulty of patent searches in the IT field. In the IT field, technology advances at an extremely rapid pace, so patent-related infrastructure may not be able to keep up with technological progress. For example, patent searches are conducted using patent classification, but if patent classification does not correspond to the latest IT technology, it may be difficult to conduct an efficient patent search using patent classification. Also, regarding technical terms, different companies may use different terms for the same technology or the similar technologies. For these reasons, even in patent searches that focus only on technical terms, some publication may be overlooked. Basically, it seems effective to use a query that combines technical terms and patent classification together. But in any cases, for patent searches in the IP field, it is best to consult patent attorneys with programming experiences. In Japan, patent database called JPAT has been released, and it is also available in English, but at this moment, it is not possible to combine patent classification and technical terms in one query. In order to conduct the more accurate search, we recommend that you consult with an outside expert, such as patent attorney or patent agent, to conduct patent search. Finally, we would like to introduce our firm, Tokyo IP Consulting. At Tokyo IP Consulting, patent attorneys who have worked at searching firms and have programming experience conduct patent searches. Additionally, Tokyo IP Consulting's patent attorneys have a history of handling a number of litigation cases. We would appreciate it if you would consider asking Tokyo IP Consulting for patent searches in Japan. Thank you for your attention. で、ちょっとこのセミナーは同時通訳はなかったんですけど、日本人参加者の皆様のためにちょっとだけ日本語で解説したいと思ってます。特許調査っていうふうなことで、やっぱりその目的を明らかにした上で特許調査をしてほしいですねっていうふうな話ですね。例えば、質問前に調査をする場合と、それから、無効審判とか、その第三者の特許を潰すために調査する場合と、それから実際に市場に上市をするときに、FTO サーチっていうんですけど、障害になる特許がないかどうか調査する場合で、見る特許の件数も決まってきますし、それからどういう言語で見なきゃいけないかとか、そういうことも決まってくるので、そこは考慮した上でやることがよくて、で、やっぱり単に似た、パッと見で似た文献があるかどうかってことだけではなくて、実際それが例えば特許出願するときとか、それとか、無効審判とかに使えるかとか使えないかとか、それから障壁なのかないかっていうのは、やっぱり特許独自の判断基準でやっているので、あるいは裁判所の判断基準でやるので、そこはやっぱり弁理士とかパテントエージェントとかにちゃんと相談した方が効率的な調査はできると思ってます。で、J プラットパッドっていうふうなデータベースが、特許庁の関連団体から公開されていて、それを使うことができるんですけど、ただ、IT 分野の特許調査というのは結構難しいというか、やっぱりIT 技術の進歩が激しくて、なかなか特許調査のデータベースの技術が、最新の IT 技術に追いついてないというか、通常、特許分類っていうようなカテゴリーを使って、特許調査するんですけど、それが最新の IT 技術に追いついてなかったりとか、あと一つの技術用語を、別の会社で別々の用語として使ってたりするので、そういう意味で、ちょっと工夫が必要で、そういう意味で、弁理士やパテントエージェントに、調査依頼した方がいいですね、というような話です。Thank you very much. Next, we will move on a talk session by Dr. Jonathan Hobbs.
Okay. So what I want to talk about is using AI to help perform a patent search. So usually the way a patent search is performed is you get the disclosure from the inventor or from the inventors, maybe if there's several inventors. And then patent attorney picks out a few keywords and the search is performed based on the keywords, usually because in the USPTO patent search database, the only operations you can perform are Boolean operators. So you can enter several keywords to do with Boolean operators to do the search. But that's really not very productive. When you're trying to write a new patent, the importance of the patent is the claim, right? So you want to really, what you want to know is what kind of claims are going to interfere with the claims that you're writing. So it's a little bit backwards what I'm using. So the search that I'm using. So I can explain more. So I already said this though. I have a PhD in neuroscience and physics. I passed the bar in 2010, and there's a couple of the recent patents that I've recently granted patents that I've worked on. Some works for Yahoo and Verizon there. So this is public patent search in the USPTO database. So you could see I've typed in robot surgery, artificial intelligence guided. I've selected the default operator as and here for a Boolean search. And the number of relevant art that appears in that search is 2,179 results. Well, that's a lot of prior art, right? That's definitely, those 2,179 prior patents are not related to this Boolean search that I've entered for robot surgery, artificial intelligence guided. So as a person that's going to write this patent, how do I find out from those 2,179 search results came up? How do I find out what's actually related? Well, you can build your own NLP, natural language processing AI in ChatGPT. So if you pay for the paid version of ChatGPT, you can create your own AI search and feed it, well, program it any kind of prompt that you want. So I created this AI search algorithm. It's called Patent Scout. And I've told it, I only want you to search the USPTO patent database. And I want you to specialize in robotic guided artificial intelligence surgery art. So you can go in, you can create your own ChatGPT with the paid version. And then you can teach it, you can train it on the claim language, the actual claim language of the prior art that's available. So I always start, every patent attorney starts with writing your claims. So I just came up with my own claim. This is not a real system, but when I think about how I'm going to write a claim for a robotic guided, artificial intelligence guided robotic surgery, this is kind of the claim that I just made up. So it's a method comprising receiving by at least one computing device, at least one image, wherein the at least one image is X-ray tomography of a section of a brain, analyzing the image with an artificial intelligence model, identifying an overly vascularized region within the image based on the analysis, generating by the at least one computing device a map representation of the identified region, generating by the at least one computing device a set of trajectories based on the map representation utilizing a robot, and utilizing a robot to resect the identified region based on the set of trajectories. So we all know, right, that ChatGPT basically produces statistically significant, semantically related sentences, right? So And claim language is completely different than any other type of language, right? It's a very specialized language that's used in claim language. So it's important to be able to train your own AI to learn what this language, how the language structure is, right? So this is the basic structure of the claim, right? So you receive an X-ray tomography image. You analyze the image with an AI model, identify it in an overly vascularized region, you generate a map of that region, generate a set of trajectories, and then resect the region with a robot. So when I input this claim, so what I'm going to do is I'm going to search for semantically relevant genre of art using my claim. So that language should, the results should produce whatever patent art that's out there that is most semantically related. To me, this makes the most sense. Rather than just doing a general, query search with Boolean operators. So here's what Patent Scout gave me. Patent Scout told me that it was going to search these 4 different areas for relevant patents, search the USPTO database. So the first thing it's going to search for is an X-ray tomography of brain sections. The second one is AI analysis of medical images, right? Because you got to identify this region. The generation of map representations, and then trajectory planning for surgical robots. So it tells me what areas of the art that it's going to search. And this actual search didn't produce anything from the USPTO database. So it went and searched the world, the internet. And it did find some related art in AI robotics. You can see the 3 different areas that it found related art, but there was nothing that came up that exactly matched those claims or the basic structure of those claims. So after I've already written this is kind of like a claim check after the fact, right? So when I get a disclosure, I'd write the claims first. I sketch out what my claims are going to look like. That's the beginning. And then you can make your drawings, if you have a flow chart or whatever. But so I want to know, after I've written my claim, what's going to be the problem, right? Am I going to run into any problems with the claim language that I have? And then if there is something, I can go in and, change the number of dependent claims or whatever. So to me, it makes a lot of sense. And this is so fast, right? Compared to just typing in some search query, this is so much faster. So the difference here is, in a traditional search, we're going to do keyword matching, right? But that's not how it works with AI, right? It's statistically semantic relationship is what AI reveals, right? It's based on what word is going to come after the robot X, whatever's most statistically, the average is, in that art that it's searching. So it's really, NLP-based search is concept matching. So yeah, that's it pretty much. The takeaways are the claims are the most important part of the patent, right? And claim-based search is more relevant to keyword query, in my opinion. You can pay for the ChatGPT customized version, build your own NLP-based AI, and it will search the art or the database that you want it to search, and you can train it on the language that you want it to search. Yes. So you can see the difference here too. When I searched the USPTO database with Boolean operators, I had over 2,000 references. And I can tell you that I've gone through that database and those references are not related. So Boolean search it's not really that valuable. So, but my Patent Scout only came up with 4. They were non-patent references, actually. There was no claim language reference from the USPTO database. So, and then the last point here is unlimited number of ARC unit-specific NLP engines for prior. Yeah, so you could train as many of those ChatGPT algorithms as you want. For example, if you wanted to train something on, engines, diesel engines, for example, if you were doing a lot of patent writing in diesel engines, you could train your own ChatGPT AI to search that specific claim language, and it's going to become even more accurate the more training that you give it. So I have just a general, Patent Scout is just kind of a general NLP claim language search system that I use. But for me, it's sort of, it's kind of a backup plan for when I have to go to office action responses. I know, what's out there that's closely matching my claims, because that's all the examiner cares about is the claims, right? So, all right, that's it for me. Thanks for watching. So I'm based in Atlanta. My phone number's listed here, and my email is listed here. So if you're ever in town, drop by and see me. So thanks for listening, guys.
Thank you. 少しですね、ここで日本人参加者のために、解説させていただきたいと思うんですけど、日本語でですね、ドクター・ジョナサン・ホブスは、NLP AI っていうふうに言ってたと思うんですけど、Natural Language Processing Artificial Intelligence ってことで、チャット GPT とかの自然言語処理 AI ってことで、こういったチャット GPT のようなシステムを利用して、特許検索システムをyou developed a system by yourself.
Yes.
独自に開発されたというようなことですね。で、ご説明にありましたように、クレームの文言に基づいて、関連するクレームと特許請求の範囲ですね、その文言に基づいて、その関連する先行技術を検索するための、プロンプト設計、NLP AI を構築する方が、キーワード検索をするよりも正確であるというようなことで、というふうな結果であったというようなことでした。で、一般的なクエリー検索では、クレーム言語を使用して、検索をすることもできませんし、そういうことで、こういったNLP AI を使ったトップ調査をされると、効率的に調査もできますので、ぜひその調査のご依頼とかありましたら、ドクター・ジョナサン・ホブスにご連絡なんかをいただければと思っています。Thank you very much, Dr. Hobbs. Well, it's a little bit early. I'd like to close this seminar. Finally, in case you have any questions for Dr. Jonathan Hobbs, Tokyo IP Consulting would like to share with you IP Solutions contact information. So please feel free to use it if you have any questions. Thank you for attending today's seminar. Have a nice day.